someday, this hasn't happened yet, when things really turn sour, say, why didn't you tell me about environmental insurance? Here's the key to solve my problem. And I just like, I always want to be able to say, I like it. And sometimes they don't want to buy it, and sometimes they just don't have it in college. And so I always like to. Yeah, it's a really good. It's like a lawyer liability protection thing to avoid. Yeah. Okay, so we'll get rolling. So welcome back from lunch. So here we are. We're going to talk about environmental insurance. And I know what you're all thinking, like all of you. Environmental insurance, lawyers. What could be more boring? I'm going to use this opportunity to return all my emails. Well, it reminds me, and I think of this all the time, many of you have seen Legally Blonde. If you haven't, you should see the movie Legally Blonde. It's really a terrific movie. But she comes home from college, and she tells her dad, I want to be a lawyer. And the dad says, they're so boring. Well, since I was very offended, and ever since then, I've promised I am not going to be a boring lawyer. Well, we have two lawyers up here on the panel, Travis and I, and we are going to give you a really powerful presentation, and our other presenters also, who have the misfortune of not being lawyers, but that's okay. They're still really good guys. But pay attention. You're going to be inclined to return your emails because it's insurance, and a lot of you are engineers and scientists, and I don't want to know about insurance. And I get insurance at home. Nobody's ever read their homeowner's insurance policy because it's so tedious and awful, including me. But pay attention, because we have some real answers here on how to finance environmental remediation, especially PFAS that you're going to be hearing about. And so please, please listen, try and stay off your emails if possible, because we have some really good answers for you. So let's go right in. Our first presenter will be Travis Hearne. Travis Hearne. Travis is a very seasoned environmental lawyer with Mechanik, Nuccio, Hearne, and Wester in Tampa. And Travis will be addressing environmental insurance from a legal perspective. Please help me welcome Travis.
Thanks, Jim. All right, thanks so much, Jim. Really appreciate the introduction. Thanks so much. Again, I'm Travis Hearne. I'm an environmental attorney out of the Tampa area. I know a lot of folks here know me, know my family. We've been in this business for a while. So I'm just going to kind of kick it off, give it sort of a general overview. A lot of the folks over here have a lot more knowledge than I do. I have just enough to sort of set them up and let them run with it. So I'm going to sort of give just sort of a background. So, the insurance world in general, and especially in our industry of environmental, there's really two kinds of policies, sort of in a big picture to distinguish between. The first kind of policy is like a first party policy coverage where, you the insured, you buy a policy that covers your own property and damage to your own property. So that's kind of one kind of thing. And then the other kind of thing, of course, is liability, the world of liability policies, where it's about a kind of, third party actor or a third party claimant that brings some kind of claim or does some kind of action that causes loss to the insured, and then the insurer takes over and defends the action in litigation and that kind of thing. So that's two kind of a distinction to make. And then the second is different types of policies. There are types of policies that are claims policies, and basically they cover a claim that causes loss where it's about whether the claim occurs in the policy period regardless of when the underlying incident that gave rise to the claim occurred. So, if the claim is brought today for an incident that happened in 1975, when a claim is made policy, that could be covered, but under the other type of policy, which is occurrence, the policy covers, it's not about when the claim is made, it's about when the underlying event giving rise to the claim occurred. So those are it's kind of a key distinction to keep in mind, especially when we're talking about environmental things, because, in the environmental world, we see a lot of this kind of circumstance where something that happened a long time ago is causing loss today. So it's kind of, we might call it temporal matter in the environmental world. There's, longer lengths of time between the occurrences and the claims that result from them. So as a matter of some kind of history, basically, before CERCLA, as we all know, CERCLA was kind of one of the biggest sea changes in environmental law that's occurred. And it gave rise to this regime that we have today that we all understand, where basically, if you own the property, it's your problem, and then all of the contributors to the contamination are jointly and severally liable, and we have contribution, and we have Superfund, and all that kind of thing. So you can see how for insurers that were issuing CGL policies prior to the passage of CERCLA and RCRA, it was like all of a sudden there's this it's like the law created an entirely new kind of liability that had never been really kind of addressed in the industry this way before. So as a response, the insurers realized they can't have this kind of giant, opening for all kinds of huge claims to sail through for, many millions of dollars on environmental cleanups. So the CGL policies, it became routine for the CGL policies to include a pollution exclusion. So, here on the slide, there's kind of an example of what this language looks like. So, basically these exclusions exclude, so in this case it's bodily injury or property damage, which would not have occurred but for the release, basically, of pollution. And then pollution is, defined differently in different types of policies. But long story short, I'm going to talk a little bit about this in Florida. The definition of pollution is broad. So basically, these exclusions of coverage, they apply to things like microbes, smoke and soot and ash, all a kind of large contaminant, a set of contaminants or pollution writ large, if you will. So of course, originally people thought, well, this exclusion, this was designed to exclude coverage of these cleanup type conditions, like we all work on the property's been contaminated, and there's contaminated soil and groundwater, and there's a claim to be paid for, but that's only one tiny sliver of many different kinds of environmental liability that can be out there, especially with the way courts in Florida have interpreted this law, where you can see some of these cases where microbial and airborne contaminants, sewage, indoor allergens, carbon monoxide fumes. There was one case where a bar was pouring liquid nitrogen into the patrons' drinks. I guess that's a mixology thing, from what I understand. Not my field, but I guess they were doing that. And when the patron was injured by that, brought a claim, they said, well, the liquid nitrogen is a contaminant, and this coverage is excluded under the environmental exclusion, and that was upheld by the court. So you can see that some of these coverages, we think of it in terms of environmental remediation, but that's just one piece of it that it addresses that and covers that. But there's a much larger world of types of claims that some of these policies can actually cover that we may not think of. So for our clients, there's value added there beyond even what we're doing. We say, well, these things can affect and address the types of claims that we assist you with, but there's other kinds of claims they can address too, outside of our world altogether. And personal injury, of course, is something that people are kind of concerned about. So in our experience, we handle mostly transactions. So we're trying to get deals done and look for ways that clients can understand their risk as best they can, and then ways to kind of reduce their liability. So environmental insurance becomes very important, because, and as the folks here are going to talk about, so we have an underwriter and a broker and another attorney, people who really understand these policies, and they're going to talk some about the types of products that are available to plug this gap in coverage. Because one of the things that we see, there's different kinds of liabilities on the environmental side that clients are often concerned about, and one of those is personal injury. And so a lot of our clients, they put sites into brownfields, where I'm sure everybody knows that the brownfields program has a liability protection that kind of cuts off liability to third parties for additional cleanup or for off-site kind of property damage and diminution of property value and that kind of thing, but it doesn't cover bodily injury. So bodily injury is one great place, an opportunity where if you have someone, a potential lender, a transaction partner that's frightened of that, or might have need assurance about that, there's policies available that will step in and cover that. And a lot of those policies too can cover kind of unknowns, because it's the world of insurance, we all know, right? Insurance is about saying if you follow these precautions and you do these kinds of things, then we know that that will reduce your risk to the point where we can then insure your risk. So it's the same way in environmental. If you have investigations of the property, you have knowledge about the property, you can provide that to the insurers and say, here's what we know about the property. What will you insure? Now, of course, a lot of the insurers aren't going to, like you say, insure a burning house. You don't call the insurance, my house on fire, can you insure me against fire? So they won't often are going to exclude anything that's known. But at least you can kind of pare the risk down to say, look, we've done investigations, we've done phase 2, we've done site assessment, whatever it is, and we present that data to the insurers, and they can look at that and offer us coverages for different things at different premiums that would allow our clients to know that tail risk, there's kind of something to help tamper it and bring it down. And that's all I got. I think up next is Jerry. You got next, right? Next we got Jerry Dubrowsky from NFP. Thanks so much.
Thanks, Charles. So Jared Dubrowsky with NFP. I am a insurance broker, and then you're going to hear from Edwin Baez, who's an insurance underwriter. Edwin and I work hand in hand on a lot of deals. So if you excuse me, I have to get through the 4 or 5 pages of mandated corporate slides about NFP and who we are now that we were recently acquired by a larger firm. We are a large brokerage acquired recently by Aon, which is an even larger brokerage. So we're a little more specialized boutique brokerage. Aon is larger risk managers. Sorry about that. So anyway, where we are in the current state of the industry, so 2 main slides that we like to look at. The two of the 3 coverages I'm going to discuss today, CPL, which is contractor pollution liability, and PLL, or SITE, which is pollution legal liability coverage. One is tied to the contractors, remediation specialists, a lot of you guys and gals in the room today. What we're seeing here, this market's very robust, not too much claims activity. A lot of our underwriters love underwriting this product because it's annually recurring. Most of our contractors are generally responsible, I think, Edwin, that's a good way to say it. So we're not seeing a lot of claims with them, but the potential for claims with with contractors is constantly increasing. Next up is site pollution, and this is kind of the beefy stuff and what I love to work with. This is going to cover the actual site. Again, robust market pricing. With environmental, we generally don't see too much fluctuation in pricing, so while your property and your GL, your auto are going up 20-30% a year, we're not seeing that with pollution liability coverage. What happens is, if the underwriters have an exposure that they don't like, they don't raise the premium, they exclude the exposure. So that's typically what we see as far as year-over-year increase. There's a lot of limit left in the market. We have a lot of carriers who are offering 50 million in limits. On top of that, we can always add layers. We've stacked up to $400 or $500 million policies. So there is a lot of limit out in the marketplace for this stuff. Retentions is another way that we also deal with a lot of environmental conditions on the site, right? We may have a site that has some issues. The environmental industry, we don't deal with $5,000 or $10,000 retentions typically. When you get into my world, Edwin's world, we're $100,000, $250,000, $500,000 retentions. So we know that we have contamination on site, but we're comfortable above that level. In terms of carriers, there are, about 40-something carriers in the marketplace right now? So what I like to say is there's 40 carriers in the environmental insurance world, but there's probably only 8 environmental insurance carriers, all right? What I mean when I say that is that there's a lot of carriers who have an environmental insurance form, and just so you know, the environmental insurance forms are all custom. It's all bespoke language. There's no standard ISO environmental form. So every carrier is going to have a different definition of pollutant, different definition of pollution condition. So it's important as a broker to understand who's more favorable depending on the scenario that you're in. But within those 40-something carriers, 8 of them, maybe 8, actually have environmental underwriters, people who truly know the industry, they know the issues. Many of them were environmental consultants, environmental scientists, remediation specialists before they got into the insurance side. So it's important, if you're working with one of these policies, not all carriers are created equal, not all forms are equal, so keep that in mind. As far as claims go, claim activity is up. It's up for a couple of reasons. First and foremost, more and more people are learning about environmental insurance. So they're seeing that there's something there to cover them, so they're filing claims. The other thing that we're starting to see, a lot of PFAS activity, right? I kind of hate talking about it already. I'm tired of it, but it's a reality. It's there. So we're starting to see more policies triggered because of PFAS. We're also starting to see an uptick in mold claims. Mold is one of our loss leaders. Now, the types of policies most often associated with transactions. So we have the pollution legal liability policy, the PLL policy, which I'm going to go into a little bit, but Edwin's really going to dive into that because that's something that he does on a day-to-day basis. We have contractor pollution liability policy. That covers the insured for anything that goes on at their site, any work. or any work that's done on their behalf. It also covers our contractors, you guys who are going out to a site where you may either create a new pollution condition, right? Backhoe knocks into a 55-gallon drum of methyl ethyl death, spills it all over the site, and now you guys have to clean that up. Insurance can be triggered for that. Or you have an existing pollution condition that you exacerbate. The last policy that we typically see in a lot of transactions are the environmental lender liability policies, right? So these are done a lot of times in lieu of a phase 2. Another policy that's becoming more and more popular these days. So the site policy, and again, Edwin's going to really dive into this, but it's really covering any pollution condition on, at, or emanating from a covered location. So this could be an owned or a leased location. It could be a location that our insured is looking to purchase. It's new and pre-existing conditions. So pre-existing would be anything that's in the ground prior to policy inception. New condition is anything that happens after policy inception. So your mold claim is typically new condition, all right? On and off-site cleanup, right? We have that contamination on-site, migrates off-site. Pollution policy is going to kick in and cover that. Transportation coverage, waste or hazardous material from your site going to another site. Truck overturns, you get pulled into it, policy's covering you for that. Non-owned disposal site, that's another one that we're seeing more and more of. If your waste ends up at a landfill gets pulled into a Superfund site, you could be a PRP, pollution policy responds to that. Business interruption, you guys are remediation consultants, contractors, you all know how long it takes to remediate some of this stuff. If you have to shut down a covered location to properly do the remediation, the pollution policy is the only one that's going to kick in and fill that gap. Mold and Legionella, like I said, mold is one of our loss leaders, especially down here in Florida. Mold is considered a pollutant, right? So your remediation of the mold, your bodily injury associated with mold, the business interruption, all of that comes back to the pollution policy. And then your emergency response, also covered by the site policy. So the CPL policy, again, it's covering any work that's done at the site, either covering you as the contractor or covering your owner for work that's done on their behalf. So very often during a transaction or during a redevelopment, our owners are coming to us and saying, look, my contractor says they have pollution coverage, but either A, I don't trust it, right? They're going to show me a certificate of insurance, but I don't know how many losses they actually have, or I want to be the one who's responsible for filing a claim. I don't want to have to rely on my contractor to do that, or maybe I just want to control the cost. I want to take it out of a line item. I'm going to run with that. This way I know that the contractor and any subs who come on site are covered. CPL policy is a great way to do that. And again, any creation of a new condition or exacerbation of an existing pollution condition, that's going to be picked up by your CPL policy. So CPL versus PLL, again, CPL is covering your contracting operations, right? So you're moving the dirt at the site, that's your CPL policy. If when you're moving the dirt, you discover something in the dirt, under the dirt, 55-gallon drum of methyl ethyl, whatever you want to call it today, that's going to be picked up by your PLL policy, your site policy. If you're really going to be effective, you should have both when you're redeveloping a site. Now, last up is lender liability. This is a policy that is incredibly underutilized in my experience. So prior to entering the insurance arena, I ran an environmental risk group at Santander Bank. We were the guys ordering the phase 1s, reviewing them, and making recommendations. Typically, when we did that for a bank, what would happen is we would go to the chief credit officer, say, hey, you know, this site was a dry cleaner. We recommend maybe you shouldn't do the deal, or maybe you should escrow a certain amount of money. The name of the game was ensuring that if anything happened and the loan went into default, the bank was covered. We really didn't utilize lender liability. The reason it's becoming more and more popular today is because a lot of lenders, or I'm sorry, borrowers don't necessarily want to do a phase 2 if the bank's demanding that they do it, right? You go in for a refi, you've been with that bank for however many years, and now they say do a phase 2. Everyone's kind of taking a step back and saying, well, hang on a second. If I do a phase 2 on my property and I find something, what happens? Well, the bank's first response is, well, I'm not giving you the loan. Okay, well, we don't want to do that. So That's one of the reasons the lender policies are coming up. I also think it has a lot to do with just people's overall education, right? Environmental issues are becoming more commonplace. They're really going from environmental to business issues, and people are just becoming more aware of what could potentially happen if I drill a hole on my site and I find something, when all I wanted to do was get a refi. So lender liability is a great way to cover that if the bank is going to be okay with them not doing a phase 2. The lender liability policies are what we call a dual trigger, so it's going to cover the bank in the event of default and discovery of a pollution condition, and then it pays the lesser of the remaining balance of the loan or the estimated cost of doing the remediation. They don't pay the actual remediation cost because we all know that the banks do not typically want to be involved in managing the property. If the bank does the remediation, the bank can be foreseen as managing the property, and you can kiss some of your protections goodbye. So the banks have kind of smartened up to that. So, little case study. One of the things that's becoming more prevalent in PFAS is the driver, are reopener cases, right? So many of our clients get these no further action letters and they get all excited. They hold it up, oh, I'm good to go. And then they read the last line that says something to the effect of, we reserve the right to reopen this case at any point in time. A lot of our clients don't understand what that means. They think the NFA is the end-all be-all. It's not. It's temporary. We're seeing a lot of cases reopen in Jersey, up north, New York, we see it. So we had a client who bought a site, no further action letter in place. A couple months later, they got a notification from the, I think it was NYSDEC, to reopen the case. I'll reopen the case. They notify the carrier as soon as they get the letter. Carrier takes over and pays the claim. Anything they find after that, it's covered. So this is probably not the most popular topic in this room, but it goes hand in hand with what we're seeing on the lender deals. More and more people are reluctant to do the phase 2. And a lot of it is being driven by sellers who don't want anyone digging a hole in their property. You're either going to take it as is, or you're not going to take it at all. There are times when I do think a phase 2 is absolutely necessary, and I think you're out of your mind if you're not going to drill a hole and find out what's going on. But there are also times when I think you can get around it utilizing insurance. Edwin and I have worked on a lot of deals together where the site use isn't going to change. No aspect of the site's going to change other than the owner that's coming in. They're going to take on the operations. They're going to move ahead with it. And insurance is a mitigant to that. So you can put the insurance policy in place. There are certain exclusions available, like a voluntary site investigation exclusion, that, look, as long as you don't drill a hole on your own, you're okay. If a governmental entity comes in and says, hey, drill a hole, well, then you're covered. So just kind of food for thought.
Jared, excuse me, I'm sorry, that's the lender liability policy that you're speaking of?
Well, we do, so the no phase 2 can go either on a lender liability policy or a site policy. So kind of either way. And then what are we looking for? I'll be quick because I'm getting the orange light here, I guess, which means I have to shut up soon. When we're underwriting these deals, I need to know who we're representing, the buyer or seller. Do they have environmental counsel? I highlight environmental counsel because environmental attorneys truly understand the deal, they understand the laws, they understand everything that's going on. I have had every type of counsel approach me on some of these deals, and they just don't understand the nuances that are involved. I've had trust attorneys, I've had tax attorneys, real estate attorneys, now we're getting a little warmer and closer, land use attorneys, but if you don't have environmental counsel, your broker should probably refer one. I am not an attorney, I never pretend to be one, so I like to have one in the room with me when I'm dealing with these. Do they have an environmental consultant? I see a lot of deals from my clients before they've spoken to any consultant. So very often they're saying, well, who should I talk to? Who's a good consultant, right? So we want to have that in place. Where's the property located? Obviously, different states, different regulations. Is that transaction going to trigger some law like ISRA in New Jersey or Act 2 in Pennsylvania? What information do we have available? You would be shocked at what people come to us with. Sometimes nothing other than an address, right? So happens. Are there pre and post closing obligations? What types of environmental indemnities are going to be involved in the transactions? Is there insurance in the purchase and sale? Is there a requirement in the purchase and sale agreement? You know, one thing I find as a broker is not enough brokers are reading the purchase and sale agreement. What does it say? That should outline everything that's going to be needed in the insurance, and the insurance should wrap around the purchase and sale agreement. Any specific coverage grants within the PSA? Is there any redevelopment? How much subsurface work are we doing? Are we just repaving a parking lot, or are we digging out a basement? And then is there any debt in the deal? Because debt comes with requirements also. So I'm going to now pass this off to Edwin. Edwin and I work hand in hand on a lot of deals, so he's going to talk about the site-specific coverage.
Great. Edwin Baez. I am with Beazley Environmental. I've been with them 8 years. I've been in the environmental insurance industry for 25 years, mostly out of New York, but I'm spending enough time in Florida. I moved to Florida 13 years ago. It's kind of becoming even. And you know when you're getting a little older. My niece is actually graduating this May from NYU Engineering, and she's studying environmental engineering. And I was talking to her about acid rain, and she had like zero idea what I was talking about. So just how time, when I was coming out, was the hot topic in 2000, and now it's non-existent. A little bit about Beazley Insurance. We're a specialty insurer, so we don't do middle market, we don't do construction, we do specialty stuff, the stuff that kind of everyone runs away from, we run towards. So we're doing cyber, we're doing healthcare, we're doing deadly weapon protection. Environmental is kind of one of those specialty items that we insure. We're publicly traded on the London Stock Exchange. That's our stock symbol. I think we're like 750 pounds, which is, I believe, a pretty good number, pretty stable company. And I'll talk a little bit about our financial strength soon. But overall, we write $6 billion in gross written premium. We're an A-rated carrier, so a lot, and this is pretty important when it comes to environmental. We're one of the few segments that write 10-year terms. So if you're going to place a 10-year policy, you want to ensure that your insurance carrier is going to be there in 10 years. And so the financial strength of the company is very important. You probably want to stick to someone's at A+, A minus. Once you're below the A minus, you're essentially out of business. So be mindful of that when you're talking insurance. Beazley Environmental is very different than kind of the other companies that I've worked for in the past. We're basically 20 very experienced underwriters who've been in the business for at least 15 years. And I guess we're a London syndicate, so that kind of fits that mentality of entrepreneurship. But they trust the experienced people to make the right decisions and write the right opportunities for the company. All we do is fixed site environmental, so we're not doing pretty much anything else. People are buying and selling contaminated properties, and we're usually the ones involved. We're not doing very much contractors pollution liability or environmental casualty. No, this is our bread and butter. This is what we get up for. And we've kind of got a reputation for taking on the more difficult risks. This is all we do. We don't have an environmental casualty book to support us. And fixed site pollution is what we do all day, and so we're dedicated to it. And so we have to be kind of the best in the industry. The core product is called the Eclipse, and it's a site pollution policy. Again, no other insurance that I can think of, and I've worked for many companies, or even think about your homeowner's insurance or your auto policy or for your company, their practice policy. They're usually 1-year terms, and we're putting out 10-year terms. And there's some variation. Some people buy 1, some people buy 3, some people buy 5, some people buy 10. Sometimes we say, hey, your operation is too risky. We want to do an annual term. We want to do a 3-year term to make sure it's operating correctly. But in theory, we're doing up to 10 years. And a lot of that is driven by private equity, lender, loan terms. So that's why the 10 years is required in our industry, in our segment. We can write up from 1 million opportunities all the way up to 25 million. So pretty broad spectrum of how much limit we can put on any specific deal. Our deductibles go as low as $25,000. More kind of middle market business. We do some middle market business, and so that deductible needs to kind of reflect that. Kind of, if you have a shopping center, it's not the same as a large chemical manufacturer. So And our minimum premium is about $25,000, just to give you an idea of what we're talking about as far as cost. The idea behind the fixed site product when it was created was kind of the EPA cradle to grave. So you create something, you transport it, and you dispose of it. And that's kind of what the standard pollution policy kind of does. Third-party bodily injury, third-party property damage, and then cleanup cost. That's kind of the site. Disposal cost, which is actually disposing the material, transportation to and from the site, business interruption if the pollution conditions basically is so bad that it shuts down your operations. That's something that can kind of reimburse you for those costs. And then natural resource damage would be kind of like a property damage, that potentially your site created natural resource damage. Indoor air is also a big concern. Mold, Legionella, asbestos and lead. Bacteria is kind of a newer one. We're still kind of getting our hands around that one. I would say that at this point we're either doing disinfection costs, which is basically cleanup cost only, or we're doing sublimits, deductibles, but we're definitely creative about it. Asbestos and lead-based paint, a little bit of a different animal. Obviously they're in the building already, but we can provide bodily injury and property damage for those type of things, or accidental disturbance if someone a contractor would come in and disturb the asbestos and lead-based paint. Just to kind of give you, I'm going to talk a little bit about what's considered a pollution condition, just to kind of get your mind thinking about it, and I'll even read out, in my next slide, I'll read out how do we define a pollution condition or a pollutant. Here, smoke is one that we consider a pollution condition. Oil spill, we consider a pollution condition. Or chlorine gas release, we consider a pollution condition. Odor is a big one, especially in South Florida and other cities where we're getting closer and closer to existing landfills and manufacturing operations that everyone would kind of stay away from. So odor is a big one for us. We see multi-million-dollar claims associated with odor sometimes. The one that isn't is noise. So that's not a pollution condition. And kind of what helps us kind of differentiate a little bit is molecule. Is it a molecule? And noise is more of a sound wave, so that wouldn't qualify as a pollution condition. To read out, this is our definition of pollutant in our form. Just to give you, I want you to see how broad it is. It's basically any solid, liquid, gaseous, or thermal irritant, contaminant, or pollutant, including but not limited to smoke, vapor, soot, fumes, acid, alkalis, chemicals, toxic or hazardous substances, waste materials including medical, infectious, and pathological waste, low-level radioactive waste, and material into or upon land or structures thereupon, the atmosphere or any water course, body of water, or groundwater, which results in bodily injury, property damage, or cleanup costs to which this insurance applies. Pollution conditions include the presence of Legionella, meiomyia, sorry, I'm pronouncing that incorrectly, phyla, sorry. So, and microbial matter on, at, or within any structures at the covered location. Pollution condition does not include any exposure to infected humans or animals or contacts with bodily fluids or infected humans or animals. So basically viruses. That's the only kind of thing that's out. And in certain cases, that's even negotiable. A lot of what we do is manuscripted. So the client has a need, and we're open to kind of hearing what they have to say, the procedures in place, and being able to help them achieve what they want to achieve. Who buys this product? Real estate developers. So obviously they're breaking ground and they're scared of what they may find, or they even have investors that are requiring them to buy the policy. Property owners, lessees, sellers, merger and acquisition clients. They're buying companies, and nobody wants to kind of sign off on the environmental indemnity, so they say, hey, let's transfer this liability to a pollution policy. Real estate investment trusts, REITs, are a big buyer. Even some of the bigger publicly traded ones buy site pollution. Manufacturers, cold storage warehouses. You see a lot of those ammonia releases in the news, so that's something that they buy regularly. Especially with warehouse space being so big these days. I mean, I think during COVID, I want to say at least I wrote 15 Amazon Wayfair distribution centers. It was just like bang, 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 just because they wanted the space to ship things out. Hospitals, their hospitals are challenges because of the obviously people with weak immune systems, but they're also always expanding and redeveloping, and they have underground storage tanks and things of that nature that have to be accounted for. College and universities, similar. Oil and gas industry, pipelines, fracking, underground storage tanks. I talked to a lot of my environmental friends, and we talk about all the things that are going on in the U.S. with regards to manufacturing and chemicals. And I think most of them have told me that at the end of the day, the two biggest polluters are dry cleaners and gas stations. So hotels, microbial matter is usually a big deal there, indoor air quality. Transportation risk, what they're transporting, it could be, and how they're transporting and what they're transporting. Obviously, we have that big release that occurred in Ohio a couple of years back and with regards to the railroad. And municipalities are also a tough one just because they're involved in so much industry, landfills, schools, airports. They have a pretty diverse listing. So how do I approach this? I want to kind of give you an idea of what happens a little bit at my desk. And usually people are I had a mentor who told me, Edwin, no one's coming to us with clean sites. So everyone's coming to us usually with a contaminated site. So that proverbial, the house is on fire, doesn't really apply to us. It's people are coming to us with issues. And usually, for the most part, we're pretty creative, and we obviously have to exclude the knowns that are going to be remediated, but we can provide you some liability protections for those knowns. So bodily injury, if someone were to sue you for bodily injury, property damage, that would be something that our policy would be able to provide you. And then the unknowns, sometimes we have, we have a pretty good idea, all right, well, the manufacturing, you'll be surprised how often this happens, the manufacturing facility, it's a 50-acre site, the manufacturing all took place at these 10 acres. So everything around the site, we don't even need to test because it's clean. From all our sandborne maps, we didn't see anything be constructed around the facility. Little did we know, as soon as that development goes up, we find out that they were dumping something, drums that weren't accounted for in this supposedly unknown area, clean area. So that happens a lot. And then, my job is to kind of bridge the gap, right? You give me information, phase 1, phase 2s, and my job is to come up with a solution using kind of my industry knowledge and kind of find a way to be successful here. Sometimes the data is not ideal, and in those situations we have the ability to use high deductible sub-limits, voluntary investigation exclusions, capital improvements exclusions. So it's kind of different ways to kind of get to the point where we want to get to, where the client's happy, we're happy, the investors are happy, and that's a lot part of my job because at what point do we stop sampling? And then the other good thing about our policy is that we can, everyone can kind of be a part of it. Like I said, you've been involved with the site for 30, 40 years. You don't want to be the one signing off on environmental indemnification for the site, and the lender wants the protection if anything goes wrong, that they're protected. So everyone can kind of be a part of the policy, buyer, seller, investor, future tenants. So it's a kind of the place to go for environmental risk transfer. PFAS, my favorite friend. I spoke at the PFAS conference the last 2 years here, actually. And, everyone's going to beat up on PFAS, and obviously it's a challenge for all of us. But I can say there's a few mitigating factors or positive things I can say. From our perspective, it's not new to us. We've been underwriting PFAS for 7 years. We had our first PFAS claim 7 years ago. So it's been on our radar. The industries have changed. The industries that we expected to be an issue are issues, and some that we weren't expecting to be an issue are issues. So that's the challenge for us, is what industries it applies to as opposed to. And we've had other challenges in the environmental segment before, MTBE, asbestos, microbial matter, when we didn't have the ability to exclude it or mitigate it. So it's not something complete. It's just a range of the applicability. So how many industries are affected by PFAS is kind of the biggest challenge for us. Drinking, right now it seems like the focus is on drinking water. So that's also a good thing for us because, a lot of the deals that we work on are usually, let's say, industrial sites and surrounded by other industrial sites. And, from talking to some of my colleagues and partners in the environmental remediation world, like Edwin, They're not going to make us, if they make us clean up PFAS here, we're going to have to clean up everything else around this site, because it's a contaminated area. And there's no receptors of concern. So it's very, very unlikely that they'll make us, and that statement depends on the state, because we've had some unlucky situations too. But for the most part, we see that taking place, that some common sense is going to step in and we won't have to remediate to an unreasonable standard. Other good thing about PFAS is that we don't have a vapor issue so far. We're not seeing a vapor concern with that, as opposed to, I say my biggest enemy is probably chlorinated solvents. That's the first thing I'm looking for when I look at a submission, just because it's goes somewhere and it can potentially go into people's indoor air quality or vapor their residential communities. And the remediation technology is getting better. So I think a couple of years ago we had the PFAS annihilator being exhibited here, and so the technology hopefully is catching up to that. I think the most important thing for us is kind of full disclosure. Give us whatever you have, and we'll give you an idea of what we're thinking from an insurance perspective, what the risk transfer would look like. We can kind of use public information to fill the gap. A lot of states have good environmental information available for us to kind of to work around whatever you can give us or whatever's available. Experience can help. Obviously you should ask who's your underwriter and how long they've been in the business and what their specialty is and even that environmental insurer, what do they specialize in? Are they more into the environmental casualty world, or are they more into the site pollution world where they do this every day? And your product or your ability to do that risk transfer depends heavily on that and their reputation, how long they've been in the business. We've been in the business 15 years. We're probably one of the oldest environmental insurers now that some of the older players like AIG and Zurich have exited. So we're not shy by hypothetical situations. Feel free to, my information, I'm on LinkedIn. I'll leave some cards, whoever would like to speak to me afterwards. But we aren't shy about having a conversation. You give me what you have, and I can tell you, hey, these are my concerns. This is what I think we can do, and that's a good way usually to start. I'm a big fan of sleep and night coverage, and this drives a lot of our businesses. All right, you do all the due diligence. You do what you typically do. Due diligence, NFA, and your client's going to drop $20-30 million on a project, and he's like, hey, I'd rather spend the extra $50 in case, $50,000 and get that reopener coverage, or if someone were to sue me for third-party liability, it's worth it to me. What's 50, 100 grand when I have 20 million invested, 30 million investors invested, and some of it's investors' money as well. So I'm a big fan of that, and that happens pretty regularly. That's pretty much it. Thank you for your time.
Thank you, Edwin. So I'm Jim Rigano, an environmental attorney. I hail from New York, and I'll be giving a presentation for Nick Rigano, my partner, who wasn't able to make it today. So I'm going to be talking about general liability policies. So first, let me make sure it's clear. So there's really two types of policies that we're talking about up here. One is general liability policies. So virtually every business and municipality have, even you, for homeowners, have general liability policies. And what they cover, it's basically litigation insurance. Somebody asserts a claim against you or a municipality or a business. Could be a lawsuit, or it could just be a nasty letter. The EPA sends a letter saying you're liable. That's a claim. And it's something that is potentially covered, more about that in a moment, under a general liability policy, which are intended as broad-ranging litigation insurance, really subject to exclusions. The second type of policy we're talking about are specialized environmental policies, which is what Edwin and Jared are talking about. And I can tell you on specialized environmental policies, I have many clients, real estate, property owners, many others, all have potential liability, and I tell them all, everyone, to consider environmental insurance. And I would strongly suggest that you all do that. Most of you are scientists, engineers in the environmental business. And it's really a good idea to suggest to your clients that they consider environmental insurance more for their own benefit, but please excuse me, for your own benefit also. You don't want them coming back to you in the future and saying, hey, why didn't you tell me this insurance was available? I might have bought it, and it might allowed me to avoid this huge expense that I'm incurring. So two very different types of policies: general liability and specialized environmental insurance. I want to talk about general liability policies and where there is a real opportunity for the issue that's all the rage today. You all know what that is, PFAS. So where is there real potential for PFAS coverage under general liability policies? Travis might talk about this in a moment, but long ago, 70s, 80s, general liability policies adopted nationwide a pollution exclusion. No coverage. And everybody today hardly thinks about general liability policies for pollution coverage. But big mistake, because there is a real opportunity. And that is for municipal policies, and municipalities virtually always have general liability policies, and fire departments will have general liability policies. And at least many municipal and fire department policies I have seen have pollution coverage for fires, crashes, explosions, and sometimes training. So what does that mean? So a municipality operates an airport, and most airports are operated by municipalities, and they have a PFAS issue from having used firefighting foam for a crash, a fire, perhaps for training. Well, there's a very strong position that there is insurance coverage there under their general liability policies. Something that is little known, and I can tell you why it's little known. It's the same reason you haven't read your homeowner's policy. If I asked you to honestly tell us who's read their homeowner's policy, none of you have. I know, because who wants to read that? It's awful. You know, you get your assurance from your carrier or your broker that you got your policy, you have your homeowner's insurance policy, you're good to go. You're not going to read that incredibly tedious policy. You know who feels that way? Everybody, including lawyers. I've had to read hundreds, maybe thousands of policies. Everyone was a struggle and difficult, but we have to do it. Well, these municipal policies will very likely have an exception to the pollution exclusion for, as I said, fires, crashes, and explosions. And I've seen some that include training. Lots of training with firefighting foam, and it causes serious issues with contamination. And almost always, historically, there'll be a plane crash at an airport, use of firefighting foam, potential contamination, and that should trigger coverage under these general liability policies. And I'm not talking about really old policies. I'm talking about policies that have just been issued. This fire, crash, explosion exception, it's an exception to the pollution exclusion, meaning there's pollution coverage. So many airports have this pollution coverage. And it's something that is really not talked about, which amazes me. And it's not talked about because nobody wants to read their policies. But you know, if you look at if municipalities were to look at their policies carefully, they would see this exception in there. Same deal for fire departments. They're almost always municipal entities. They almost always have this same exception for pollution. Fire, crashes, explosions, often training, or at least sometimes training, and they may well have insurance coverage. And these policies are almost always millions of dollars, often tens of millions of dollars. And there's very significant coverage there. And it's something that is just being ignored. And it amazes me that it's being ignored. So airports, fire departments, they really have a very strong opportunity to get millions of dollars from their carrier. And of course, you put in the claim notice to the carrier. Is the carrier going to say, yes, we have a check for you here? You know, it's going to take some doing to get them to pay up. But you know, if it's brought to their attention that we have these facts and your policy says that there's coverage, they will, in my experience, step up to the plate. Might take a little bit of battling, but they'll step up to the plate. And it's not something they're expecting to cover in the typical case. I would like to talk a little bit about the Biscayne Aquifer and Biscayne Bay, because it's a really good illustration of what's going on. So I have recently become a part-time Miami resident. My son lives in Miami, and I've read a lot about PFAS in Biscayne Bay. you may not know Biscayne Bay. If you, I like to refer to the popular media. If you remember Miami Vice, some of you do. So there was Don Johnson driving his speedboat across, well, it was Biscayne Bay, from Miami over to Miami Beach. And I thought, wow, that is so cool. I didn't know it was Biscayne Bay at the time. But it's a beautiful body of water. Recent studies, academic studies of Biscayne Bay have showed pretty high PFAS levels as PFAS goes. You all know we're doing PFAS in parts per trillion these days. Back in the day it was chlorinated solvents in parts per billion, and now here we are in the parts per trillion world. Sorry to digress. In any event, Biscayne Bay, some pretty bad PFAS levels in Biscayne Bay. And the studies have shown as you get closer to Miami and further from Miami Beach, on the really densely populated area in Miami, closest to Miami in Biscayne Bay, the PFAS levels really go up. And there's a couple of rivers that drain into Biscayne Bay from Miami. And those are obviously the sources of PFAS getting into Biscayne Bay. And what are those sources? Well, there have been investigations done, some dry cleaners, et cetera, but the real culprits seem to be fire training facilities. I think there's insurance coverage there. And there have not been, as far as I could find, that I've really looked, studies at Miami International Airport and Opa-locka Airport, kind of an executive jet airport. And at least in my experience with airports, all the airports that we've looked at, they have PFAS from firefighting foam. And it appears that they are real sources of the PFAS entering Biscayne Bay. And you know what? And this kind of blows my mind, that both airports should have, and I expect they would have, pollution coverage. And yet it's not being explored. And yet there it is. And I'm pretty sure they could get millions through insurance coverage under their general liability policies, because of this exception to the pollution exclusion that allows for fires, crashes, explosions, and sometimes training. A big pile of dough there. And we're not talking about taxpayer burdens here or the government. We're talking about getting the insurance company to pay under their insurance contract. So just to go on a little bit about Biscayne Bay, you don't know. You probably don't know. I've looked into where Miami and Miami Beach gets their water supply from, and I was very troubled, so troubled. It comes from the Biscayne Aquifer, and where is that but underneath Miami? It has to be contaminated with, what is it, millions? Is it 3 million? I'm not sure of the number. People living on top of their aquifer, their drinking water supply. And the levels in the water supply are about 20. The last number I saw in our most recent report was 30. And the EPA, the very recent 2024 EPA drinking water quality standard for the two key PFAS chemicals is 4 parts per trillion, 4. And so Biscayne Aquifer, fire training facilities, the airports, insurance coverage, likely. I mean, really, there's a solution in all of that. Finally, I want to talk a little bit about the MDL. And some of you know what the MDL is and what I'm talking about, but what it does not mean, method detection limit, which, MDL, you all know about that. It's the multi-district litigation centralized in South Carolina, hundreds of nationwide lawsuits for firefighting foam PFAS contamination. Many of them are water districts that are suing for treatment. Many of them are for bodily injury. Some of them are for subsurface contamination cases associated with PFAS. And so we're involved with the MDL. There was a recent, last year or so, settlement with the water purveyors, $13 billion. That's a lot of money coming from, and the lawsuits are basically PFAS manufacturers, 3M, DuPont, several others, Tyco, who are being sued. This litigation has been going on for years and years. So they just settled within the past year or so $13 billion for the water purveyors for treating water. Miami-Dade Water District, I believe they're going to get $200 million. Ultimately, this is going to come out over several years. $200 million for Miami-Dade Water District, and I'm sure several other water districts here in Florida for treatment of their water. Well, I just heard this. Really, it was just this morning that now in the MDL there is significant talk and progress on settlements for remedial costs at airports. And so if there are airports, and I know there are because there have not been a whole lot of claims across the country, and I think, as far as I could tell, no claims I've seen at airports here in Florida for firefighting foam PFAS. And by claim, it could just be a nasty letter from any third, could be from a citizen group, government, anybody, for demands for investigation and cleanup at airports. Well, airports are now on the front burner at the MDL settlement. So if you know of airports and they have not made a claim in the MDL, take some work. You need a lawyer, of course. But they should be making claims in the MDL, that is airports, for these costs. And they'll probably get a pile of, I'll just say a pile of dough. How much money remains to be seen? Long way to go. But these are now on the front burner. So the MDL is really something to look at if you're involved at all in airports or municipalities or your uncle that might get involved with operating an airport. Really, really, really important. So that brings me to the end of my comments. I'm also the moderator here. So we're going to take questions for our panel. And I have a few questions here, but first, let me turn it over to the audience. Anybody in the world of insurance on any questions? So I'm going to turn to Travis on the liability policies. So, I'm sorry. Yes, sir. Thank you.
I have a question regarding the lender policies, and particularly when a phase 2 is not conducted. Several similar questions, so instead of just going back and forth, I'll just list the questions. What is required to apply? How long does it take to get a response? You know, transactions are usually quick turn, so that time frame is important. What are the exclusions in those policies? And are you seeing more larger lenders or smaller lenders utilizing these policies?
Okay, so typically all that's needed for the lender policy, phase 1, loan to value ratio, debt service coverage ratio, loan amount and loan term, right? Once we have that information, the underwrite is typically done in a week or less, sometimes within the course of a day. Go ahead with the rest of your questions, I'm sorry.
Okay. What exclusions are provided in the policy?
So typically on the lender policies, we do not have exclusions. And that's one of the draws for the lenders, is that you're not going to have any exclusion. It's event of default and discovery of pollution condition, the policy is triggered.
Okay. Are you seeing larger, smaller? Are you seeing a trend in the types of lenders?
Yeah, typically we're seeing smaller lenders. Regional lenders, community banks are the ones who are relying on it more. I've had some discussions with some of the larger banks, and they're pretty opposed to it. They're standing by, well, we've got an environmental group and we're going to do whatever they say. Right. You know, what I've found in my experience, and I ran an environmental risk unit at a bank for a number of years, the environmental people, they don't always have a say in the decision, right? The decision's going to be with the chief credit officer. So unless the chief credit officer knows about the product and the opportunity to use it, it doesn't happen. The smaller banks, the regional banks, it's easier to get to that chief credit officer and have them make the decision, present them with the product. You know, what we are seeing, though, is a lot of deals that are walking away from the big banks, the Chase, Bank of America, and now coming to these smaller regional banks, the thrifts, and they're the ones who are pulling the trigger and using the product more.
Yeah, that makes sense. I would imagine the smaller lenders are utilizing it more. Is there any coverage for the borrower?
So yes, depend on a true lender policy, you're not going to cover the borrower, you're only protecting the lender. But what we are starting to see in the industry is some hybrid product that in the event of default, the policy then transfers to the lender. You know, one of the hardest sells for the lender policy is having someone pay for the policy that doesn't give them any protection, right? But the flip side of that is, okay, fine, I'm not going to get any protection out of the deal, but I'm going to get the deal, right? That's really what it comes down to. I'm not going to have to do a phase 2. I'm going to get the loan. It's not going to be that painful, and we can move on with it.
And is this same line of coverage applicable not just for lenders, but also in site policies that Edwin was talking about?
Yeah, well, that's kind of what you were saying. You were saying if you want coverage for the borrower.
Edwin, you should use,
Yeah.
you gotta
Can you-
flip it on.
If you want coverage for the borrower, then you would switch to kind of my policy and kind of make it so that the exclusions don't apply to lender. So the lender will get a lot of the benefit if there's a default. So if they stop paying, the borrower stop paying, then the exclusions don't apply to the lender. So we get to pay for the cleanup, but we're only paying for the cleanup. We're not paying for the balance of the loan. So if you're a true lender, you get the balance of the loan or the cleanup. If you move to my world, and we do lender too, but if you move to the site policy, you're only going to get cleanup. You're not going to get the balance of the loan. But both entities are protected under our policy as opposed to a lender where it really is only the lender that gets a protection.
Okay, thanks. Last question is pertaining to reopeners. Can this same line of coverage be provided before a reopener risk comes up?
So when you say before a reopener risk,
So the property owner receives the no further action letter and they're thrilled, but they read that last sentence and they suspect there may be a benzoate pyrene or a PFAS or something else there that was not assessed under the remediation. Is this same type of coverage available for property owners?
yeah, so we would put a site policy in place that would cover that. And we would typically look to cover, depending on what's going on at the site, obviously, but as long as we have coverage for pre-existing conditions, you know, you may have a voluntary site investigation exclusion on, which basically says, look, don't go and do a phase 2 on your own, which most people generally don't wake up on a Saturday morning and say, hey, I'm going to drill a hole in the ground and see what we find. But if a governmental entity comes in and says, listen, you've got this no further action letter, but we have reason to believe that we didn't sample thoroughly or we didn't sample at the time and look for XYZ, now we want you to go sample for it, that's enough to trigger the policy and open it up.
Thank you very much.
So we got a question over there in that back corner.
Can you give us some range of costs of policy to protect the bank with $1 million loan, a $2 million loan, a $5 million loan?
Yeah, I mean, it's all deal dependent. However, hang on, let me get to you. But typically what we'll see is with a lot of the lender policies, you know, some of the ones I've done recently, from $1 million to $5 million, what's going to drive a lot of the premium is the loan term, right? So the shorter loan term, premium's typically lower. But I'm seeing anywhere between $19,000 up to, I had one the other day, it was about $70,000. And that's a longer loan term, like a 13-year term. So
A lender policy in theory is cheaper than a standard site pollution eclipse policy because you have the dual trigger, right? So it's not just a pollution condition, it's a pollution condition and default. So technically it's cheaper. The site pollution policy is just a pollution condition. So it theoretically should be higher.
The term limits that I see are generally 5 years.
So you're probably, I mean, look, it's going to depend on the loan. You're probably at the bottom end of that.
So if just to follow up on that, because that's a really good question on the term limit, if the loan is for 10 years, which a lot of commercial loans are, can the coverage be for the life of the loan?
Yeah, so the longest I've seen them go out is 13 years. You know, environmental policies, like Edwin said, 10 years is the longest that we can get a site policy for. There was a time long ago when carriers were writing 20 and there were rumored to be 30-year pollution policies. The carrier that was writing those is no longer writing any pollution coverage anymore, for obvious reasons. So yeah, we can go out 13 years is the longest I've seen.
Thank you. Yes, we had a question here.
Yeah, so it was mentioned that sound is a wave and hence not a pollutant. OSHA says otherwise. It's you know, up to certain decibel levels, it's considered a sound wave. After that, it's a noise pollution. So just curious why it was excluded as a pollutant. We are adding so many new pollutants every year we are learning about. Why is that excluded?
So, like Edwin said, and one of the reasons I love dealing with pollution policies or pollution insurance is because it's all manuscripted, right? 40-something different carriers. We've got 40 different definitions of pollution condition and pollutant. It can be manuscripted in as a definition of pollutant. You just have to find the right carrier. We are seeing that more and more with some of these battery substations that are being developed. So there is a drive for it, but noise and odor can be considered pollutant. It's just, it has to be with the right carrier who's willing to do it. We have to have the data to support it, and the client has to be willing to pay for it. You know, most of the pollution policies that Edwin and I deal with, we're not in the realm of, you know, a $10,000 policy. Our world typically exists north of $100,000. So it's there, you just have to be willing to buy the coverage, or to pay for the coverage.
Quick point on that, Jared. Because actually, I just read, in preparation for this, I read some of those cases about that question of what's contaminants and what's not. I think, you know, that we use the term noise pollution. Obviously, that's like it's like an idiom or a phrase we use. But I think when you look at the cases and the way they discuss these policies, the way they get to this distinction is by saying that the term contaminant is really kind of a key thing. And so that's why anything that's like a particle, you know, particle that is somewhere the particle doesn't belong is a contaminant. But I think, you know, when you think about, you know, the character of noise, I mean, you know, we're all sitting in an ocean of air, and when the air vibrates, you know, it's not, there's nothing out of place. You know, even though the air is vibrating too fast, that it's unpleasant to us, there's not a contaminant or anything that's really like pollution. So I think that's kind of the reason, kind of the legal reasoning. And of course, that all comes from courts interpreting the policies and the language in the policies. You know, so to the extent that language is the same, I think what Jared is saying is correct. The language could be different. You know, we can write a policy with different language in it, different definitions, but I think it's kind of the standard way.
And Travis, as a follow-up to that, so you get the pollution policy proposal from your broker and your carrier, and there's some things you want added. Can you speak to negotiations with the carrier and the broker about, you know, what you might want added to the policy?
Try to think on that one for a second. I mean, that's a little bit of a stumper. I'm trying to think of things to add to the policy. I mean, obviously, you want the most favorable terms you can. Jared, you go for it. You take this one. He's gonna use that.
So, like I said, every carrier has different definitions. So it's really important when you're doing this, you're working with a broker who knows his carriers, right? So we want to pick and choose which carrier we're going to go to. But within that, there's certain things you want. Choice of counsel is a big one. Right, we want to make sure we have that manuscripted into the policy. If you are working with a specific environmental attorney on a long-going case, it's important that they're included in the policy. We negotiate the rates ahead of time. We negotiate anything about them into the policy so that if the policy is triggered, that's the attorney that's getting the phone call, right? So that's one important thing. We very often will schedule consultants onto the policy. We'll do that as well. And then you have certain little nuanced things like choice of law, where the policy can be tried, right? Edwin, this is one we always have deleted. We don't want it to be tried in New York. We want it to be tried somewhere else. So little nuanced things that just come from experience with doing these.
So, Edwin, client has a chlorinated solvent site. They're worried about getting sued by neighbors or maybe even employees of tenants for bodily injury, or maybe they're concerned about the neighbors suing for decrease in property value, you know, third-party actions. The plume, maybe it's going underneath a neighbor's house and they're upset. And the client, who's the owner of the property and the owner of the chlorinated solvent issue, is troubled by these third-party actions for bodily injury or decrease in property values.
You should
So,
be.
covered?
Yeah, that's kind of the house on fire, right? So obviously you have an issue, you know you need to address for it. It's
I'm sorry, let me add one. No claim yet, just a worry by the property owner.
Oh yeah, no, that absolutely. It's still the same. Even if someone comes to me with a shopping center, I'm thinking, and especially an older shopping center, you're thinking dry cleaner, you're thinking printing, you're thinking gas station, you're thinking auto repair, you're thinking tire recycling or tire installation because of the lifts. So the whole bandit of potential issues. But yeah, dry cleaners are the biggest ones. Typically in that type of scenario, you're looking at, maybe not providing coverage for, you can either exclude the knowns, how sure you are that that's gonna, there is a plume there, that's kind of dictated by what you know about the dry cleaning operations. Was it closed loop? Was it on the basement? Was it on the first floor with a basement? So you're kind of running through all these scenarios. And depending on whether you think there's a plume or not, you have to exclude for cleanup costs, so hopefully you're still giving bodily injury and property damage, which is liability protection, or you can do something along the lines of maybe a higher retention with a voluntary investigation exclusion or capital improvement exclusion. So depending on the groundwater levels, what state you're in, those are all the different dynamics that go into that type of scenario.
But specifically for, as you say in the industry, BI, bodily injury, or PD, property damage, there's a real prospect for coverage there, I think.
Yeah, absolutely.
Right?
We want to help you find a solution. We're in the business of helping you find a solution. So usually, at a minimum, we can pull off bodily injury and property damage. There's some patients you can't save. Obviously, if they're already in litigation, that's an issue. But most of the time, we can find a solution. A lender policy wouldn't be a bad case in that, if it's being driven by the lender and you have that dual trigger, that's not a horrible scenario either.
Yes.
I haven't heard anything about golf courses. What's the latest in the market? Are you still seeing a lot of policies being written for golf course transactions?
Operational golf courses or former golf courses?
Mostly former abandoned golf courses that are being redeveloped into some other land use.
So I've seen a couple, none recently, but they're still happening. I mean, it just depends on the transaction. Typically, you'll see probably a pesticide exclusion, given what was there. But, remediation, it's going to depend on the site. Some they get back and they're not so great, I think is the nicest way to put it. And then others you get back and carriers can get comfortable with what was there and what was used and how it was utilized, and they can put the coverage in place. We saw a couple recently down in northern Palm Beach County. I think that was the last one we saw. And there were no significant exclusions. I think there was one exclusion for remediation of pesticides, but there was no exclusion for bodily injury or property damage associated with it. So, okay, fine, we're not going to pay to clean it up, but you know what you're buying, and you should take that into consideration when you're developing it, is the potential remediation cost. Where a lot of my clients are coming to me is, what's the concern for third-party bodily injury and property damage claim? Because remember, a pollution policy can be triggered on the allegation. So we didn't even have to have proof. Someone can come at my client and say, my XYZ illness is because of what was at your site. Prove it. And now defense is going to be triggered. And that's a lot of what we see on these policies is defense. That's where a lot of it's paid out.
Great answer, thank you. That it's that third party concern that most people, that's the biggest unknown.
Yeah. And you're not talking about, when that's triggered, you're not talking about your typical attorney. You're talking about a specialized environmental attorney to handle that type of scenario. Okay? So it's a lot more costly when you can't have your cousin do that type of work,
So in that scenario, the exclusion would be related to remedial costs, which the developers probably already factored in. You're covering their unknowns regarding third-party claims.
Yeah.
And then also, for remediation contractors and on projects, there used to be cost overrun insurance. The scenario would be the performance-based cleanup where, the cleanup costs are worked up and there's an agreement over fixed cost for cleanup, performance-based cleanup. Are those still available and under what circumstances, and how strict are the exclusions, or basically the trigger on those policies, as I understand it, is something new comes up during the course of the remediation that was not there in the original remediation plan. Can that still be covered?
So cost cap, as we call it in our industry, it is still around. It never completely went away, but I've had a couple deals quoted recently. So it's cost overrun protection, right? Client comes in, they think it's going to be $3 million to remediate the site, but what if, right? What if it's going to go over? So it is still there, but it's being underwritten much more conservatively than it ever was before. So the reason I think it went away for a little while was because you had some property owners, and this is from what I was told, you had some property owners who were working closely with their consultants to come up with a number. They were giving it to the carrier, and it was probably a lowball number, right? So as soon as you hit that number, think of that $3 million cost as your retention. Once you hit that, the policy's triggered. But now what's happening is the product is available, but all of your information now has to go to a third-party engineer that the carrier picks. The client is paying for it, and the carrier is not always going to agree with the number that your consultant gave them. And I've looked at a few of them with some really reputable big-name consultants, and they come back and say, we think it's going to be closer to 8. We don't think it's going to be 6 million. So if the client's willing to accept the 8 million, they'll do it, and they'll give you, I don't know, 5, I've seen up to 10 million in excess of whatever that remediation number is, up to 10 years. The thing is, it's not the type of policy that you can buy and put on a shelf, right? Like the coverage that we were talking about for the no further action letters, you buy that, you put it on a shelf, and you hope to never have to use it. The cost overrun is a very involved product, right? So it's not available to every broker. It's available to a select number of brokers who are going to be involved with the process. And that process is quarterly or monthly reporting to the insurance company to say, look, this is where we are. It's not like, you get to 2.95 million, call the carrier and say, hey, look where we are. It doesn't work like that. They're going to want to know, how did you get here? Where are you in the process? What's going on? And there has to be a cadence with that. It has to be reported in. But they will pay.
Makes sense. In those particular claims that you are still writing, are the clients or applicants more the site owner or more the remediation contractor?
They're done on behalf of the site owner.
Thank you.
So Travis, a policy expired long ago. There is no pollution exclusion in the policy because it was such an old policy from the 70s. We have chlorinated solvents, big potential cleanup costs, coverage.
I mean, I think Jim, it's the question of the occurrence type policy or the claims made type policy, because, and I mean, if I were an insurer, I don't think I would want to write an occurrence-based policy, because it seems like your future period for claims is like infinity. There must be some cutoff or something. I mean, I guess it's just different kind of from industry to industry. Loss type and risk type. Environmental seems like you could have a longer period between the occurrence and the damage because of the way environment works. It's not like car accidents where it happens and the damage is suffered immediately and the damage is addressed immediately. It's something over time. But back to what Jim is saying, yeah, I mean, if the policy is an occurrence-based policy, then you would have to go back and show that the occurrence happened during the policy period. So you'd have to probably a close reading of that CGL. I would think too that as a result, especially for these occurrence-based policies, you want to kind of take it, put it in a vault, and just make sure you keep it forever. Because what if one day, you go back and you have to see when all these policy periods were, and this thing happened 150 years ago? I don't know. I honestly don't know how that's handled. I would think, be kept pretty closely, but long roundabout way of answering it. Yes, it is possible.
Yes. So pursue coverage under these old policies. And interestingly, you don't actually need the policy. Secondary evidence, like a letter from another carrier or from a broker, is sufficient to demonstrate coverage under policies long ago when they did not have a pollution exclusion. And it's pretty well established when the pollution exclusion started. Edwin, PFAS exclusion. So you issue a new site policy for cleanup. No PFAS contamination known of in a phase 2. Do we get an automatic PFAS exclusion in the policy? And
Sorry, you said the policy's already in place, or you?
yeah, no, you're applying for the policy. It's not in place yet. And the site policy, phase 2, no PFAS information in the policy, not an airport or a fire station, maybe not a dry cleaner.
If it's an industry that's not associated with PFAS, then there wouldn't be a PFAS exclusion. So we have a kind of a list of, all right, these are the industries that we're concerned with.
Pick up the microphone.
Sorry, if it's an industry that's not associated with PFAS, then more likely than not, you're not going to have a PFAS exclusion. We have a list of, all right, these are the industries that we need to be mindful and careful with when it comes to PFAS. I mean, obviously there's some, when you're doing redevelopment, you're not 100% sure what you're going to find. But for the most part, if there's, again, not a history, if that industry is not associated with PFAS, you shouldn't have a PFAS exclusion. Even though that list is pretty broad these days when it comes to PFAS, car washes, dry cleaners potentially, so we'll see how that continues to play out.
Thank you. So something that just about everybody here should have is a consultant or contractor policy. So Jared, can you speak to the contractor environmental consultant policies? And just to give you a little bit of a scenario, had a contractor, wasn't my client, I wasn't involved until afterwards, but the contractor, remediation contractor, and the consultant put in a boring. They were too close to the lines at a gas station. They hit the lines, caused an oil spill. And I was not aware that they received insurance coverage for that. But aren't these policies intended to pay for, I'll call it, mistakes made by the contractor or the consultant?
Yeah, so again, everyone in this room should have or be working under a contractor pollution liability policy, and it's going to cover you for creation of a new pollution condition or exacerbation of an existing pollution condition. So the scenario you described generally would be covered. The policies are underwritten largely off of your revenue. They're done on an annual basis. And then the contractor coverage can be combined with your general liability coverage and also with professional coverage. So we do sell a lot of combined form policies. So it's your GL, CPL, your contractor, and professional. So that's something that everybody in this room should have. Those are 3 coverages you all need. You probably all have GL. You more than likely have some level of contractor pollution liability coverage, and then you hopefully have some level of professional coverage as well. So yes, that's available.
And what are the typical limits?
So typically it's done on an annual basis, and it's going to depend on the contractor size. Usually $5 million and under in limit. But we do have some very, very large clients who they're buying north of 10 million. So it all depends on what your revenue is, where you're doing the work.
What the client dictates.
Yeah, and then the type of work you're doing also, right? We have some environmental remediation contractors, and then we have some very large contract, like electrical contractors, plumbing contractors, guys who are doing sewer and road work. So it really just depends on what you're doing, but it's widely available in the marketplace. It's an easy underwrite, and most carriers they love the product because it's done on an annual basis, and the losses are low. I'll just keep knocking for Edwin's sake.
Travis, did you want to add something? If you could take the
On that
microphone.
one. No, so this is one? Yeah, this one's on too.
we go.
So, we often help our clients hire contractors. So it's a big part of what we do. We help them kind of bring on board. We do the negotiations, and all of those contracts always require the contractors to carry that type of contractor's pollution liability. And then it always requires the contractor's pollution carrier to name our clients as an additional insured. And I've seen, and this is kind of more of a general question, you probably answer this really quick, that a lot of those policies on the contractors, they have an endorsement provision that basically says if you enter into a contract with someone who requires you to name them as an additional insured, that's automatically done under the policy.
Yeah, so there is blanket language. It's I personally like scheduling people to the policy, so I know definitively. I know some of our underwriters hate that because you get these bigger jobs where they're coming out and it's like, hey, schedule this one, schedule this one, schedule this one, and I don't know. Me personally, I like to see their name on there.
A lot of times a client wants to see them specifically listed as additional insured that are just standard policy language. I mean, it's the same thing, but it's just they want to see their name in lights. Right.
All right, gentlemen. Well, thank you very much. Give our panel a round of applause. Thank you. And I believe that brings us to our coffee break until 3:30. Thank you.